so they might be, some said up to a month to 2 months out.
That's pretty typical.
Yeah,
That's pretty typical.
so I don't know if that exceeds the time limit that I have, or,
Well, it could, but ordinarily, if the problem is not years of the making, the problem is scheduling. It's Stratfield, it's a contract between the city and Mr. Wilson. If you're willing to give Mr. Wilson an extension to allow him to do that, we can reset the matter out.
The city's fine offering an extension.
Yeah, well, we just
I mean,
wanted,
I'll make an appointment today, then show confirmation of when it will be set for, when I did get in.
let's say, let's assume a month. This is November. Let's set it to the first date in December, maybe? That'd be December 7th,
Perfect.
the day that will live in infamy. Sorry. And if by then, that's all you have to do to resolve the matter. It's if we have on file proof that you've done that, I'm pretty certain that'll take care of the matter. Well, you might, if you're able to get it done by then, get proof on file here and then check with us the day or so before court to make sure we have it. And that'll take care of the matter. How's that? You know, it is one of the hoops you have to jump through, and hopefully it'll be something you'll learn something from. I had occasion, not I wasn't ordered to, but I did attend one of these sessions with a friend that was under the obligation, and I thought it was pretty informative. Is life going okay otherwise?
Mine?
Yes.
Yes, sir. Other than being too expensive.
You know, this is one of those things where time goes by, it'll drop off, this drops off your record, your insurance premiums will go to et cetera, et cetera, et cetera. But yeah, and life in general is getting more expensive. I'm going to sign a order resetting the matter to December 7th, and we'll just see how things are then. Hopefully be able to conclude the case. If not, we'll deal with it then. Cross that bridge when we get to it. Mr. Wilson, I want to thank you for your patience. You've been here, I guess, for quite a while. You can get a copy of today's order by going to the window outside the courtroom and to your left, and that'll take care of the matter.
Good to go.
Good luck getting
Have a good
that
day.
done. That's scheduling is a problem everywhere. That leaves we're now at 8:30. And we have some no-shows. First one on the diet would be Samuel Hubbs. Mr. Hatfield, any position on the case? Looks like an SOC, with a new violation and money owed. Theft third charge.
Mr. Steve.
Just give them the benefit of the bargain and
Yeah.
close. I think given the nature of the offense, that was probably a good case management decision.
Yeah.
The next one, however, is Simon Rowley. That's a DWI.
Uh, 25.
So ordered. A non-appearance on a DUI noncompliance, that is, it's a little troubling. The next one is Matthew Victory, and that's one of those
this was supposed to be dismissed with Mr. Vick bringing up.
Oh, okay.
Track.
So ordered. Infraction dismissed.
I am not hearing him. Judge, I'm looking for the sound.
Evidently, you can't hear me.
I can hear you now.
Here, perfect.
Yeah.
We're now on record. Who are we going to have first? Do you know?
Well, let's go ahead and take up the matter of John Langdale. He's here. I'll have him come over and have a seat here. Morning, sir.
Mr. Langdale, for the record, your name is John Romolo Langdale.
That's correct. And the matter, Judge, comes on for a pretrial hearing today. And there's a couple charges, a DUI and a hit and run unattended. I think the parties have come to an agreement. I've reviewed the police report with him, and we've talked about the case and all the consequences for the DUI. And he's proposing to enter a plea of guilty to count one, a DUI, reflecting an amendment to that of no test, which would yield the mandatory minimum penalties. Upon the court's acceptance of the plea, city would move to dismiss count two, which is the hit and run unattended charge. And, you know, the recommendation is just all of the required mandatory minimums, along with chemical dependency evaluation, follow any recommended treatment, victim impact panel, the mandatory costs. I think at this point, I'm not sure if he's been held here on Yelm on this versus being held by Lakewood, but he may have credit at this point, or the court can give him credit and be released on this matter. But from what I understand, there may be a hold from the city of Lakewood.
I understand there is a hold from another jurisdiction regarding a similar charge.
Yeah, I looked on Jabs yesterday. It must have been so new it hadn't hit the system yet, but that's my understanding from talking to the Yelm Municipal Court clerk.
I understand it to be a DUI. With that, does that change your position regarding?
No. Oh. I don't believe it changes the recommendation between the parties here. Obviously, it's gonna change the strategy on what he does, you know, on his next, you know, DUI. And I did mention to him, I don't represent him on that matter, but I mentioned to him he might want to speak with his attorney that he's appointed to in Lakewood. He may want to look into deferred prosecution or some other options.
Mr. Langdale, for the record, is your name John Bromlau Langdale?
Yes.
I'm looking at a statement of defendant on plea of guilty to one count of DUI with a dismissal of a hit and run unattended. The plea form tells me you're 66 years of age. Did you have any trouble at all going over the plea form and the process with your attorney?
No, sir.
You realize if I accept the plea, you could be sentenced up to the maximum, which would be 364 days in jail and up to a $5,000 fine.
Yes.
And if I accept the plea and the conviction goes in, the Department of Licensing will take action with regard to your driver's license in a manner determined by your record.
Yes. Yes, I understand.
And if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing. Is that correct?
That's correct.
With that in mind, as to one count of DUI alleged to have occurred within the city of Yelm on February 8, 2023, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, I do.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. The recommended sentence is for what they call the mandatory minimums. Mr. Ratfield, anything to add to the recommendation contained in the plea form?
No, Your Honor. Yes.
Mr. Haverco, anything to add at all?
No, Your Honor, just would ask that the court follow the recommendation, that being the mandatory minimums, and That's
Mr.
nothing
Lang,
else.
anything you wish to tell me? You have a right to tell me anything you wish regarding the matter. Now's the time. You don't have to say anything. But if you have anything to say, now is the time to do it.
No, sir. I have,
I am going to follow the recommendation 364, 363, suspended on some conditions I'll go into in a minute. The one day I'm going to give you credit for time served on that. You've been in jail for more than a day by far. $990.50 fine has to be imposed, and I'll impose that. You're to get a drug and alcohol evaluation within the next 90 days and then file proof of that with the court. And the jail time is also suspended on the condition that you have no criminal law offenses, especially when it comes to substances and driving. Any questions at all?
no, sir.
Mr. Langdale, that concludes the matter. I'm going to wish you the best of luck. I understand you're being held on the Lakewood matter, but you should have court, I understand, sometime today. I'm going
Okay,
to wish you the best of luck. You take care. Stay in touch. Make sure we have a current address on file, and you might retain contact information with Mr. Haverco to just in case you have any questions. Okay.
thank you very much, sir. Appreciate your time.
He'll have a copy of today's paperwork, and he can share that with you, and go over it carefully and call him if you have any questions. Good luck.
Thank you.
Thank you, Aaron.
Morning, Mr. Scott. I don't have to ask who you are because I lost track of how many times I've seen you on video. But I will defer to Mr. Haverco for the status of the matter. You were booked in on a couple of new charges.
He's been in jail since around the 3rd. So the matter, Your Honor, the matter comes on before the court today for an arraignment on new charges of criminal trespass 2nd degree and a controlled substance knowing possession charge. I have discussed with Mr. Scott what an arraignment is, which is to be read the charges in open court, the elements the city would have to prove, the maximums that could be imposed, and a reading of his rights, right to constitutional rights and so on. And it is his choice to, he's electing to waive arraignment if the court would accept that. And he would like to waive arraignment, ask for court appointed counsel. I'm here, and then he would like to deal with the matter today, and he's proposing to enter a straight plea to count 1, criminal trespass in the 2nd degree, and then upon the court's acceptance of that plea, as part of the plea bargain, the city would move to dismiss count 2.
Mr. Scott, do you disagree with anything at all Mr. Haverco just said? Again, I'm appointing him to represent you in this case as well. He has represented you in many past cases. You're familiar.
No, I don't.
Hey, so I'm looking at a statement of defendant on plea of guilty to 1 count of criminal trespass 2nd degree. There's also referenced a dismissal of a controlled substance charge as well. Have you gone over the plea with Mr. Haverco?
Yes,
Had any? I know we've gone through this before, but I have to ask you, any problem at all reading, understanding the plea form?
no,
If I accept the plea, you could be sentenced up to 90 days in jail and up to a $1,000 fine, this being a misdemeanor. And you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing.
okay, thank you, yeah, yes.
Mr. Scott, as to, and I forgot that, for the record, your name is Paul Harvey Scott.
Yes,
As to one count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on October 3rd, 2023. How do you plead, guilty or not guilty?
Guilty?
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
I will find the pleas to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. The recommended sentence is credit for time served. The balance is suspended on the condition of law-abiding behavior. Is there anything you'd like to tell me?
No, it's just I won't go to that park again. They caught me on camera at the park, and that I just won't. I won't go there again. I apologize.
Mr. Haverco, anything further?
Well, it's just unfortunate. It's one of these things where, he is violating the law, but it's just unfortunate that he's gotten himself in a situation where he wasn't, in a sense, causing other trouble. It was rather, he's gotten himself in a situation where he's committing a status crime by virtue of just being where he is. And, like he's mentioned to me, it's like he's been trespassed from so many parts of the city. It's challenging for him, I think, and so it's just unfortunate.
Redfield, anything to add to the recommendation? That's Mr. Scott, do you know how many years in suspended time do you have? I can't count that high.
Yeah.
No, I'll impose 90 days and I'm tempted to impose them all, but I'm not going to. I'm going to give you credit for time, 10 days served, suspend 80 on the condition that you have law-abiding behavior. And as Mr. Haverco said, you're running out of places where you can go in public within the city because you've been trespassed, made yourself unwelcome just about everywhere you go. And as we both know that your behavior is related to what you put in your body. I'd like to see you say, I don't want to read your name in a report, which I'm going to one of these days, unless you put that stuff down. That's I'm not going to go into the statistics about what fentanyl and heroin have done by the way of putting people underground. I'd like to see you save your life, okay?
Okay. Yes.
Let's give it another try, but it seems like every time I sit here, I'm talking to Mr. Scott on the by way of a Zoom call from the jail. I'd like to see you address the situation. You're young enough, I think, to where that could you could turn things around. Please consider that, okay?
All right. Thank you.
Scott, you can thank me by thinking about maybe some of the things I've said. Good luck to you, okay?
Thank you.
Take care. Yeah, so we're done with these guys, and now we just need Alex, James, Brown. Okay. Yeah.
I didn't say no.
I'll be in contact with you.
Okay. All right. Yeah, appreciate your time. They're going to be bringing Mr. Brown. He was, I'm not sure if he was being held in isolation, but he was in a different
Yes.
spot.
This may take a bit of time.
Oh,
When I call the jail on the PC, the status call, sometimes it takes 10 minutes to persuade Mr. Brown to attend. Hesitate. It looks like we're in a kind of a hiatus here. So I have people waiting. If there's something that could be handled really quickly, risking that Mr. Brown will come out, I'll defer to.
I think we could squeeze.
Wait, sir, go ahead and have a seat.
for your honor, this is Alex James Brown.
Mr. Everco, we're gonna take care of another matter here.
Oh,
But put you on standby and.
okay. Okay,
Good morning, and I'm assuming this is Mr. McGuire?
Yes, good morning, Your Honor. Thank you. Thank the court for its patience. Dennis Short on behalf of Mr. McGuire, who is present out of custody, seated tonight.
Mr. McGuire, well, your matter set for a pretrial. I see in O courts a possible resolution. I'll defer to your attorney for that.
Yes, and we did have reached a resolution with the city, Your Honor, for a 6-month SOC. It's appropriate given the particulars of this case. This case is intertwined also with a family law matter. The court knows those things can get messy. And so given the facts of this case, both the city and I think this is an appropriate resolution. My client has already finished its chemical dependency. Things will be filing that as part of the conditions of this. He understands that after 6 months, making sure he's keeping his nose clean, staying out of trouble, the city will then move to dismiss objection. But if he fails to abide by those recommendations, file proof of chemical dependency evaluation treatment, if he gets any more trouble in those 6 months, that the court will just read the police report and decide guilt or innocence based on that. So I believe he understands what he's entering into. Your Honor will find that he is entering this agreement.
McGuire, I hope you heeded and understand everything your attorney just said. Your attorney's worked out an avenue by this charge can get dismissed about 6 months from now if you do some very simple things. Stay out of trouble. Stay out of trouble, especially when it comes to the domestic relations side of things. Now, in return for the agreement, which will hopefully lead to a dismissal of a pretty serious charge, you're giving up a number of rights that are contained in the agreement. And as your attorney said, if the city proves by a preponderance of the evidence that you violated the agreement, we'll have a hearing based on the police reports and nothing more. And that will result probably almost certainly in a conviction for a pretty serious offense, which will have subject you to the possibility of going to jail. But more importantly, it does horrible things to your record. Your attorney's put you in a position where this matter can go away, but now compliance is up to one person, and I'm looking at him right now. I'm going to wish you the best of luck. I know these domestic situations, they get fraught with emotional distress of one kind or another. Get through it and go on with life. That's all I can say. Good luck to you. You can get a copy of today's agreement by going to the counter outside the courtroom to your left. I want you to read it over carefully and give your attorney a call if you have any questions. Any questions?
Nothing, just please approve my electronic signature. I didn't bring it. So that's my electronic signature. Say approved.
Well, good luck to you. You take care of yourself, and you owe your attorney a debt of thanks. Good luck.
Thank you, Your Honor. Thank you, Counsel.
Thank you. I knew it. Now, we would have been ready to go if I just called that right at the very beginning. I think Mr. Haverco sort of stepped off calendar there. We could maybe message him that we're ready up. Mr. Haverco, we're ready to go.
Yes, sir. Let me, I'll just have Mr. Brown reseat himself here. Mr. Brown, yeah, go ahead. Before you go ahead.
Good morning, sir. Is your name Alex James Brown?
Yes, sir.
Mr. Brown, I'm the person that you spoke to on the phone yesterday and then the day before. It's good to see you in person. I'm appointing Mr. Haverco to represent you with regard to your cases, and I'll turn to him now for the status of the matter. You're set for arraignment today.
Okay.
Yeah, thank you, Judge. He's got a couple matters that are on for arraignment today. The first matter, criminal trespass, second degree. The second matter, also criminal trespass, but first degree. And he understands that as part of an arraignment, the procedure would be to be read the charges in open court, the elements that the city would have to prove, if convicted, the maximum sentence that could be imposed. He understands that procedure, what an arraignment is. I've had an opportunity to review the police reports with Mr. Brown. The city was kind enough to get those to me fairly quickly. And he would like to take care of these matters today if possible. He'd like to waive arraignment on both of these matters. And then as part of a proposed resolution, he is proposing to enter a straight plea of guilty to the case ending in 427 to the charge of criminal trespass in the second degree. And the recommendation by the city would be simply just suspended jail time. Because of his indigency, I don't believe the city was recommending a fine. Conditions for the next 12 months just to remain law abiding. And then as part of the overall agreement, Upon the court's acceptance of the plea, then the city would move to dismiss the other case, ending in 447.
Mr. Brown, do you disagree with anything at all your attorney just said?
No, I do not.
I am looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, which references a dismissal of a charge of criminal trespass, first degree. Have you gone over the plea process with your attorney?
Yes,
And if you had any questions at all about what it entailed to enter a plea of guilty, were your questions answered?
yes, there was. Yes, there was.
Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and up to a $1,000 fine.
Yes, sir.
With that in mind, as to one count of criminal trespass, second degree alleged to have occurred within the city of Yelm on October 9th, 2023, how do you plead, guilty or not guilty?
Guilty.
You make that plea of your own free will.
Huh?
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty, except the recommendation as the sentence?
No, sir.
Find the plea to be freely, knowingly, and voluntarily made, and the statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Brown, the recommendation is credit for time served, remaining time suspended on the condition you stay out of trouble. Does Mr. Bradfield, anything to add to the recommendation? Mr. Haverco, anything to add?
Oh, nothing to add, Your Honor. We'll just ask the court to follow it. Thank you.
Mr. Brown, anything you'd like to tell me? You don't have to say anything, but if you want me to know anything, now's the time.
Thank you, Your Honor.
Mr. Brown, it's okay.
I love you. Thank you.
I'm going to follow the recommendation. 90 days in jail, credit for 3 days served, 87 suspended on the condition. Just stay out of trouble, okay?
Yes, sir.
We talked a couple of days ago. You were on your way home to
Mamas.
and things went sideways on the way back home,
Yes, sir.
which put you right back where you were from where I'd released you. I want you to just stay out of trouble, okay?
Yes, sir.
If you've been trespassed from somebody, someplace, don't go there, okay?
You'll never see me in your jail ever again, Your Honor. I swear to God.
That's up to you, not me. You said
Yes, sir.
you're not going to be going to jail, Mr. Brown. I'm going to wish you good luck. You take care of yourself, okay?
Yes, sir. Thank you.
Thank you. And you can thank me by staying out of trouble.
Okay.
No fine.
Okay.
That takes care of the matter.
Thank you, Judge.
You'll be released when the paperwork gets to the jail. Mr. Brown, good luck.
Thank you.
And for the record, case ending 447 dismissed. Back on the record, Mr. Haverko, defer to you for the,
Well, and I'll just, we'll take care of the 945.
Mr. Gokart, come on up and have a seat, at the council table. Good morning to you. It looks like you're on an SOC. It's been extended, through September of this year. Where are we at? What would you like, where are we? I shouldn't say where.
I honestly thought I had paid my ticket and I cleared this up. That was my belief, and then I got pulled over and said I missed the court date.
Okay, well, it looks like you still owe $250. It's an SOC. City have a position on, how will you tell the city what can you do? Can you pay it?
Got y'all like a payment plan type thing? Or
Well,
something? Or-
how long would it take you? The city would like to know that.
Well, I'm in the process of looking for work. I'm in an interview today at 1 o'clock. I just haven't had a lot of money. I'm hoping within the next couple weeks to have a job. And start paying as soon as I can, make some sort of payment plan, or maybe within like a,
I think we might have been on a payment plan already.
was it?
We were, yeah, that was extended, in March of this year through to middle of September of this year. And there still hasn't been any payment made. I think the city's probably gonna, well, I'll defer to the city.
Yeah, I think.
Usually what the city does is recommend, yeah, we simply enter a finding of guilty and close the case, not impose any fine, just end it. That gonna work for you? It's your, yep, you haven't, there really isn't anything to say about this, except you haven't done it despite given a number of months to it. I will find that there is probable cause for the sufficient factual basis to enter a finding of guilty. I'll do that and then simply close the case. I'm not going to impose any jail time, suspended or otherwise. It just converts to a conviction. That's all.
All right.
Good luck to you. Thank you for your patience. Warrant is quashed, of course. There isn't any warrant. Case is over. Thank you. And Mr. Kokot, good luck to you. Take
Yes,
care of
sir.
yourself. To do anything. Do anything with that order? Oh, okay. There we go. Anything to present? Oh,
Yeah, yes, Judge. If we could take up the matter of, on the 10 o'clock calendar, item number 9, Bradley Phillips. Matter comes on for a pretrial hearing on a reckless driving. Parties have reached an agreement. City's going to move to amend to negligent driving in the second degree.
back then. Morning, sir. For the record, your name is Bradley, excuse me, J. Phillips. And Mr. Everco, again?
Oh,
I
yeah,
was-
matter comes on, Judge, for a pretrial hearing on a reckless driving charge. The parties have reached an agreement. City is making a motion to amend the charge to negligent driving in the second degree.
Mr. Phillips, negligent driving in the second degree, as I recall, is an infraction and not a criminal offense. You admit the infraction, I'll impose a fine in an amount agreed upon or city have a
Defer to
recommendation
the
as
city
to,
on that.
oh. 250.
250.
You admit that you committed the infraction of negligent driving on September 3rd, 2023. And I'll impose a fine in the amount of $250. You can pay that at the rate of $50 a month. That'll take a moment to prepare the and there, hit the refresh button. Mr. Phillips, a conviction for reckless driving that result in a suspension of your license for 30 days and does horrible things to your insurance rates. And the Department of Licensing doesn't look at it very favorably in any event. Donnie, it's Sarah. Where? Hit the refresh. Not showing up. Brad Phillips, number 2. I've got 2 in there. But nothing. I hit the refresh. Been the wrong guy. There we go. Mr. Phillips, signing the order, setting the fine and your payment plan. Go to the window, get a copy of the order, refer to it. If you have a problem making the payments, let us know. We can deal with that. Don't want it to go to the Department of Licensing as a failure to appear. Good luck to you.
Stephanie?
Morning, man.
This is Stephanie Hodge,
Docket number is 5 and 6.
and
Good morning,
I-
ma'am.
the matter comes on for a couple pretrial hearings, Judge. Item number 5, a criminal trespass in the second degree alleged to have occurred on September 11, 2023. And then item number 6, the criminal trespass first degree alleged to have occurred on September 19th, 2023. I had prepared a statement of defendant on plea of guilty, of which I had spoken with Ms. Hodge, of pleading to the 431 criminal trespass second degree charge. City was gonna be willing to dismiss that matter. And then I was advised this morning by Ms. Hodge that she is insisting on pleading guilty to both. I did advise her that, you know, the city is perfectly willing as part of their offer to dismiss the gross misdemeanor in exchange for a plea to the misdemeanor. I mean, she does have a right to plead guilty to both charges. It's her right to do that. You know, my suggestion to her was, you know, if the city's gonna recommend, you know, dismissing the more serious charge, I mean, it's very much to her benefit to accept that offer. And I mean, that is my recommendation, but, so that's why I was taking a moment here to modify the plea form to add back in the criminal trespass, you know, first degree, charge. I need to add in the, adding back the criminal trespass, first degree charge. I mean, the city wasn't recommending any, you know, jail time. They were just recommending a single fine. I would ask that if the court proceeds with taking pleas on both, as opposed to a $250 probation fee on each, I would ask that it be split between both cases for a global total of $250. You know, would be my position that I would, you know, strongly encourage and recommend Ms. Hodge to accept the offer and the dismissal of the criminal trespass first degree charge, but that's her decision.
That's up. Good morning, ma'am. Is Stephanie Marita Hodge is your full name? Ms. Hodge, I've, from this position, defense and prosecution, from all positions, I've had a great number of plea agreements fall through. But never, I don't think I've ever had one because the defendant wanted to plead guilty to more than the offer extended. If that is your wish, and we'll address that in a minute, that's what we'll do. That's your choice. I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass second degree and one count of criminal trespass first degree. The former is a simple misdemeanor, 90 days and or 1,000 to be the max. The latter, first degree, is a gross misdemeanor, 364 and 5,000 would be the maximum on that charge. You realize that. Have you gone over the plea form with your attorney, and any questions at all that you had? Were they answered? Now, if I accept the pleas, you give up the rights contained in paragraph 5, no trial, no appeal, and I could sentence you up to the maximum regardless of what's recommended. You realize that. And so one count of criminal trespass in the second degree alleged to have occurred within the city of Yelm on September 11th, 2023. How do you plead, guilty or not guilty? With regard to a charge of criminal trespass first degree alleged to have occurred within the city of Yelm on September 19th, 2023, how do you plead, guilty or not guilty? Do you make those pleas of your own free will? Anybody threaten you to make those pleas? I will find the pleas to be freely, knowingly, and voluntarily made, and your statements in paragraph 11 do satisfy the factual elements. I've heard the recommendation of the party. Mr. Radfield, anything to add? Ms. Hodge, anything you'd like to tell me? Ms. Hodge, I'm gonna,
I've got a suggestion, Judge, if the city has no objection. Normally, the court imposes suspended time, you know, on similar charges.
I'm inclined to oppose 90 and 90 on each.
Well, I was going to ask if the court would consider just imposing no jail time on the criminal trespass first degree, just no jail time and nothing, and with no suspended time, and then just suspend 90 days on the
Well,
criminal
concurrent, no
trespass.
jail time. I agree.
Oh.
I agree. Ms. Hodge, look, the criminal trespass first and second degree that simply involve being someplace that you shouldn't have been because you're no longer welcome there. I'm gonna follow your attorney's recommendation. I'm gonna pose on the case ending 431, crim trust, second degree, 90 days, all suspended on the condition you have law-abiding behavior and a $250 fine. With regard to the second, I will find you guilty, and that'll go on your record as a conviction. That's case ending 442. However, I'm not going to impose any jail time or any fine on that charge as well. The fine and the suspended jail time apply only to the first charge. Any questions at all? You're not going to jail, not unless there's the jail time is suspended on the condition that you have law-abiding behavior. Stay out of trouble. As long as you're staying out of trouble, you don't have to worry about any jail time. Pardon? No, I'm not going to make you go to jail. Why do you want to go to jail? You see, I think you have a friend in the courtroom. Sir, is there anything, any light you could shed on this? Tell me who you are and speak. You don't have to say anything. There's as many drugs available in jail as there are out there on the street. Ms. Hodge, I'm not going to order you into any drug treatment program at all. That's your personal choice, period. These aren't directly drug-related charges, although I realize that that's often a relationship there. If you need to go through detox, there's facilities that can do that, and your significant other can help you find one of those programs. Unfortunately, there's a lot of waiting time, but I'm not going to sentence you to jail simply so you can detox. That's just not the way to go about it. Yes, you do need to enter treatment clean. They won't take you if you're under the influence or positive. You need to detox first. If you're serious about getting off drugs, I want you to save your own life. I'm familiar with way too many people that, including a brother that did not make it through a OD. Naloxone, they only can save so many lives, but I want you to save your own life. Look at getting into a program where you can detox and then get an evaluation, inpatient, outpatient, intensive. When the experts will make a recommendation as to what it takes to get you off drugs. I'm going to wish you the best of luck, Miss Hodge. You take care of yourself, and you've got the best friend in the world right there in the courtroom behind you. Let him help you. Okay. Good luck to you. Good luck. I'm still trying to figure out my computer ineptitude is showing itself these days. Perfect. Yep. Good. Got it. Not all the delay is my fault. I want you to understand that. But now I'm ready. I've caught up.
If we could call, on the 10 o'clock. Mr. Carlos A. Cisneros Chavez.
Good morning, sir.
He had, this matter had already come before the court. He entered a guilty plea.
Yes.
What no one realized was, the officer input the incorrect RCW
Oh, boy.
into the citation. And what that caused to have happen was, it caused your license to be suspended, or you couldn't.
Yeah, or they want to suspend it,
Yeah.
because the codes aren't matching up. So
Right. And so I discussed this with, the court clerk, and we were looking at the RCW. She looked up some other cases where this case is charged, and it would appear that the officer should have used RCW 46.20.740. And I think it's technically, looking at the statute, it looks like it's subsection 2, because it says, it is a gross misdemeanor for a person with such a notation, meaning the notation, you have to have an interlock device to operate the vehicle without the vehicle so equipped. So that's what the charge should be. So I discussed with the clerk, we weren't sure if Your Honor could just amend the statute, or if he has to withdraw the plea and then re-plea based on the correct statute. We weren't sure.
I'm not sure what DOL would accept. For that, I'm willing to amend that to the correct statutory citation, and I will so amend that for the record. I don't know if any orders, if that can be done on the computer. If it can be, let's give it a try. And if they accept that, that would be fine. The other alternative would be,
Just to
as
withdraw,
you suggested, a
just fully
dismissal,
withdraw the
refile,
plea and do a new plea
just
would be.
start from
Yeah.
scratch. Move to a dismiss, et cetera, et cetera. Want to give that a try? Just simply amending and,
So what he's saying. Versus withdrawing the entire plea and then doing a new plea form to the correct amended statute. The end result should be the same. What he's saying is, he doesn't know
which one?
what DOL is gonna do. So
Yeah,
if DOL says, well, we're still gonna suspend you because you originally entered a plea to that, what he's saying is you can come back and he'll let you just literally withdraw your guilty plea to the original completely. And then we can fill out a new plea form.
see if it
Okay.
works.
So what do you have any idea?
So I will go to them.
Mr. Havergal, what the,
Right,
They set up that,
okay.
so they were. Because originally, they just said.
clerk's office will contact DOL and notify them of the amendment.
Oh.
We'll see if that works.
Okay,
Yeah.
Let them know if that works.
okay.
And if it doesn't, we'll know and we can,
Doesn't work, give me a call and we'll.
Plan B.
Yeah,
we'll
that's
reschedule.
what they told me. That was just, so they were originally, they were just like, just go to the clerk, but I guess that they didn't.
we'll give it a try. Mr. Cisneros Chavez said that is something that I probably should have caught.
Well.
And I apologize to you for not doing so, but hey, we'll get her straightened out one way or the other.
Thank you guys.
You're free to go.
Good luck.
Thank you guys.
Good luck and take care. And you as well.
And Mr. Yang is here, who I need to talk with. He's the last item on the 10 o'clock calendar, but he's accompanied with a friend who has an arraignment today on the 1 o'clock calendar, which normally we wouldn't do that, but I guess my thought was, since he's here,
We can
might
do
wanna-
that now.
Might want to do the arraignment.
Certainly.
And that's Mr. Bickford. It's item number 2 on the arraignment calendar.
Mr. Bickford, would come up, go to that calendar. Good morning, sir. Is your full name Billy Ray Bickford? Mr. Bickford, the citation I have alleges on or about October 4th, 2023, you committed the offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction to be 90 days or 364 days in jail and or a $5,000 fine. If you're indigent, I'll appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time. And the plea invariably is, Mr. Haverco.
Thank you, Judge. Would stipulate to probable cause and ask the court to enter a not guilty plea.
Mr. Bickford, a plea of not guilty has been entered. What we're going to do is set the matter for a pretrial conference. That's a chance for you to go over the case with your attorney. Resolve it if you can by agreement. If you can't resolve it by agreement, you have a right to a public and speedy jury trial. We'll set the pretrial for November 9th at 11 a.m. And I want you to exchange contact information. You're going to get an order. You can pick that up at the counter outside the courtroom and to your left. It'll have Mr. Haverco's information on there, but I want you to let him know how he can get a hold of you.
There you go. And I need from you, I need a pen. Eight, 6, 3. Before you go, to the clerk before you go, she'll give you your paperwork. Oh.
Mr. Bickford, good luck. Any questions? See you in November. Take care.
I've been advised by the clerk, apparently we have a DJ Gilbert Nelson in Zoom. That's item number 9 on the 11 o'clock calendar.
That page. Ryan Morrow.
No, it's item number 9. It's last name Nelson, Judge?
Oh, DJ
Yeah,
Gilbert
yeah,
Nelson.
Right, yeah. And
Good morning, sir. You're muted. Could you unmute yourself?
Yep, I got it now.
Hey, thank you. Yeah, can you hear me okay?
Yes, sir.
Hey, your attorney's in the courtroom. We'll address your matter at this time. Good morning.
Good morning.
Morning, everybody. So yeah, this is the matter of DJ Gilbert Nelson. Comes before the court this morning on a pretrial hearing for protection order violation. I've had an opportunity to discuss the matter with Mr. Nelson. And the parties have had discussions about resolving the matter. We're proposing that the court accept a stipulated order of continuance. The conditions of which would be to continue the matter 12 months on the condition that he remain law-abiding, no criminal law violations. Pay a $250 court probation fee, just bench probation. And then at the end of which time, if he's complied, then the city would move to dismiss the matter.
Mr. Nelson, do you disagree at all with anything your attorney just said?
No, Your Honor.
Your attorney's worked out an agreement with the city. This is a contract. You're agreeing that you're going to stay out of trouble, pay $250 in costs. You do that, a year from now, the charge is dismissed. If you violate the agreement and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that will result most certainly in a conviction for a pretty serious domestic violence related offense. You realize that?
Yes, Your Honor.
You're in a position of being able to get this charge dismissed. It's up to you whether that happens or not, and that'll be determined by your conduct over the next year. I'm going to wish you the best of luck. You take care of yourself. Now, we'll be sending you a copy of this agreement. What I want you to do is look it over, read it carefully, and if you have any questions at all about what it says or what it means, let us know. Now,
Okay.
if you have trouble making the most important thing to me is you stay out of trouble. There's also the $250. If you have trouble making those payments, let us know. We can certainly deal with that. But don't just let it go if you get into a financial bind of any kind, okay?
And then I would have called the same number I called, like, to get the information to log into this, right? The courthouse out there for that, to pay it.
The information will be in the, your payments are set at 25 a month, and the
Okay.
first would be due November 12th. And now that's in the agreement. And also it says, how you can make the payments.
Okay.
In person, mail, what have you.
Okay, that's what I was wondering, is how I'd do it through the mail. So I'll look over that.
Okay, that'll be in the agreement. We'll be sending you a copy. You take care of yourself, okay?
Thank you. I appreciate it.
Nelson, thank you. You take
Hey,
care.
you guys too.
go back on record with regard to one of the attorney matters. That would be Ms. Squally from the 9 o'clock calendar. There has been no appearance. We'll simply note the non-appearance and then reset the matter with notice to her and Mr. Ross, her attorney, resetting the matter to let's go October 26th. And send notice, notice of hearing. Back on record, Mr. Havercole, you have a matter to put on the record.
Thanks, Jim.
Good morning, sir. Go ahead and have a seat next to your attorney there.
Looking around here. Oh, that, yeah, it would be under 4661, that's rules of the road. Would defective equipment, Judge, would defective equipment infraction, would that be under 4661 somewhere?
I would think it should be.
Isn't that where all the?
Effective equipment. I think would it not have to be more specific than that, like missing tail light?
Yeah, I
missing
mean,
headlight?
I'm looking for, what would cover a missing headlight, a headlight out?
That would be in the lighting. I remember seeing that in the lighting provisions.
Yeah. Is that,
Where
is
it's
that still 40,
required,
is that likely under 4661?
I forget exactly where that is. 4661 is where it should be. Don't have the RCW in front of me.
Just looking. Maybe if I just Google it here. Let's see, it looks like it actually may be RCW 46.37.040. Yes, and that's what it would be, 4637.040.
And that references.
Yeah, that is
Headlights?
headlamps on motor vehicles.
Oh, okay.
And it says, yeah, subsection 1, every motor vehicle shall be equipped with at least 2 headlamps with at least 1 on each side of the front of the motor vehicle, which headlamp shall comply with the requirements and limitations set forth in this chapter. So is that the operative one that creates the violation, or?
That would just be an infraction with a listed penalty, and that's set by the Supreme Court. So.
Okay. So that's how we propose to resolve the matter.
And this is Mr. Yang.
Yes.
Ready to go on record?
Yes.
Oh, wait. Go back on record. Morning, sir. Is your name Joshua Yang?
Yes.
Matter set for a hearing on a number of infractions, no insurance, registration, ID, expired registration, and a DUI.
And, right, and as to the DUI matter, which again comes on before the court for a pretrial hearing, upon discussion with the city and reviewing the police reports, the basis of the stop was defective equipment. It was not speeding, actually. It was
Yes.
it was a
No
headlight
license
out,
plate,
no license plate,
headlamp out. Yeah.
and the smell of marijuana. And
Yes. There was a blood draw there.
there was, and one of the officers, he doesn't mention in the police report whether or not he's a drug recognition expert, but just comes to the conclusion that he's under the influence. And so upon further discussion, the parties are concluding there's really not a sufficient factual basis to support the charge of DUI in this case, and propose to resolve it by way of amendment to the infraction RCW as previously mentioned, and then it's just a matter of imposing the costs on the other infractions.
Is if I recall from the report, there wasn't any bad driving, that I recall. I think there was simply the equipment violations.
Yes.
That was the reason for the
That's correct.
pullover.
Yes.
Yeah. Which gave the officer, sufficient, reason to, summon a DRE. Very often sometimes they're not available, but be that as it
Right.
may. Your agreement, would be to dismiss the DUI and then, deal with some infractions?
Yes.
Just the one or more than one?
Well, I'll leave it between him and the city and your honor as to how to deal. We didn't discuss the other mitigation matters, so we'll just leave that up to the city and the court on what's going to be imposed on that. But as to the pretrial matter would be the amendment to that, equipment violation, no working, headlight.
Well, Mr. Yang, what you're left with, the big one is going away, and that's the DUI. That leaves you with a number of infractions. 9/11/2023, operating a vehicle without insurance, no registration, no license on your person, expired registration, and they added a infraction of no headlamps, 4637-040 sub 1. If you admit those infractions, I'm going to impose a $100 fine on each of them. If you deny them, we can set them for a contested hearing. Any question about anything I just said? If you do, you can discuss the matter with Mr. Haverford.
He would like to do that, Your Honor.
I'll take that by way of disposition. I'll impose a $100 assessment on each of them. Now, just no insurance, that's $556 on its face. And it's, a couple of good things. It's really a good idea to have your equipment in a condition where an officer doesn't have a reason or an excuse to pull you over and find out what's going on with you. That's always a very good thing to do. Secondarily, yeah, you've got a real good break on the DUI, which is an absolute catastrophe in terms of your driving record if you were to be convicted of that. That's a conviction for DUI is, in terms of impact on your life, in my opinion, a lot more serious than a conviction for a number of felonies, So, hey, that is the best thing that happened here. What I'd like you to do is, I've dealt with too many victims, defendants over the year who, because they shouldn't have been driving, somebody got killed, somebody got hurt, et cetera, et cetera. Try and separate any substance use. That's your life, you live it, but try and separate it from your getting behind the wheel of a motor vehicle. When you get behind the wheel of a car, and you shouldn't be driving, really bad things happen. I don't know how many people I've represented, et cetera, who wouldn't step on a spider, but wound up killing somebody when they wouldn't have ordinarily heard it. So that you don't want to go there. You don't want to go there. There'll be here a infraction disposition form, which I'm reviewing at this time. $25 a month starting November 12th. Mr. Yang, what I'm going to want you to do is pick up a copy of this order at the window outside the courtroom to your left. And that's in your own enlightened self-interest. The better your driving record is, fortunately, these are all just basically non-moving offenses. They aren't going to have your insurance, but you're going to be paying thousands of dollars more in insurance if you get a conviction for a DUI or something of a serious nature. So keep those insurance premiums low and stay safe. Most important thing, your safety and the safety of everybody else using the road, okay? Good luck to you. You take care. Any questions? You can, that's your choice. The minimum is $25 a month starting November 12th. If you can pay it all in 10 minutes, That's what I would do, so I wouldn't have to, if I had the money, that's what I would do, so I wouldn't have to worry about it anymore. It's up to you. It's up to you. It's in the order, and how you can make the payments are in there as well, so you take care of yourself, huh?
You too.
Have a good one. Time will tell. That will go off record.
Yeah, no one else?
Oh, to be Back on record, Mr. Haverko, defer to you.
Thanks, Judge. So on the 11 o'clock, calling item number 10, last name Stevens, Abbott Stevens.
Abbott Harvey Stevens, good morning. Item number 11.
Judge, matter comes on before the court for a pretrial hearing on a reckless driving charge. Parties have had an opportunity to discuss the matter and have come to an agreement. That being the amendment to the civil infraction of negligent driving in the second degree.
Am I correct in recalling this as one of those contest speed cases? Mr. Stevens, you're now cited with a civil infraction. You admit the infraction, I'll impose a $250 fine. If you deny it, we can set it for a contested hearing. You would admit it or deny it? I'll impose a $250 fine. And I could sit here and bore you for the next hour or two about bad results that happen from trying to be faster than the guy next to you, et cetera, et cetera. That's familiar with a number of people that aren't here anymore because they didn't survive such a thing. I'll sign an order setting your payments at $25 a month. That's the minimum. First payment due next month in November. Any questions at all? As well as your own enlightened self-interest, a conviction for reckless driving, your license is suspended. Reinstatement requires, skyrocketing insurance premiums. You're going to be paying a fortune for insurance for a long time. Neg 2 is a lot better result. And besides, reckless driving, that's a criminal offense. You go to jail for that. It's an infraction. It's just money. Keep the money in your pocket. Pay this fine and drive safely. Keep the insurance premiums low and keep yourself and the others out there on the road, keep them safe. Good luck to you.
Thank you.
Good luck to you, Mr. Nelson. You take care of yourself. Automotive foolishness. That's Back on record?
Yeah, back on record. So the next matter, Judge, would be on the 11 o'clock calendar, item number 8, Ryan Morrow with an M, Morrow.
I have him as number 9 on my docket.
Oh, you, okay,
But I think there was an add-on.
okay.
So, but yeah, number 9.
Okay, and
Mr. Morrow, good morning.
matter comes before the court for a pretrial hearing for a reckless driving charge. The parties have reached an agreement. That being, the city is going to move to amend the criminal matter to the civil infraction of negligent driving in the second degree. And we're asking for a mutually agreed upon $250 fine.
Mr. Morrow, the offense of reckless driving, that's a criminal offense. You could go to jail if you were found guilty of that. Department of Licensing also would suspend your license for a period of time, and you would pay thousands of dollars extra in insurance over the next several years. The city is amending the charge to a charge of negligent driving in the second degree. That's a civil infraction. The only thing that can be imposed is a fine, and no jail time could possibly be imposed. If you admit the infraction, I'm going to assess a $250 fine. If you deny it, we can set it for a contested hearing. You need to talk to your attorney.
He admits it, Judge.
The admission, I will assess the $250. You can pay that at $25 a month. I realize this is one of those contest of speed type cases. Hey, look, in your own enlightened self-interest, you want to not get your license suspended, not go to jail. You also want to be healthy enough to come into court with all your arms, all your legs, et cetera, et cetera, et cetera. I could bore you over the next several hours with people that haven't been quite so fortunate. I've talked to too many mothers who got the 4 o'clock in the morning phone call. It's about your son. Well, he's upstairs sleeping. No, ma'am, he isn't. He died. You don't want to go there. You want to go there. Slow down and get there. Don't drive, Get behind the wheel of a car. Bad things happen. Driving is probably the most dangerous thing you're ever going to do in your life. Do it carefully. And keep your insurance premiums low, okay? Any questions? Tomorrow, good luck to you. You take care. And as I sometimes say, time will tell. Good luck. Thank you. Back on record, Mr. Havergo, go ahead.
Thanks, Judge.
Defer to you.
Okay. Your Honor, this is Garrett Coleman. He's on the 11 o'clock calendar. Matter comes before the court for a pretrial hearing
Mr. Coleman?
on a theft charge. He does have a prior record, no thefts, but mostly based on the factual issues in the case. The parties have come to a compromise, that being a stipulated order of continuance. Conditions to remain law abiding for 12 months, pay a $250 probation fee, at the end of which time the city would move to dismiss if he complies.
And sir, for the record, your name is Garrett Lavelle Coleman. Mr. Coleman, I'm looking at the stipulated order of continuance on this screen in front of me. It's an agreement between yourself and the city, negotiated by your attorney, under the terms of which a theft charge can be dismissed 12 months from now if you stay out of trouble, most importantly, and pay a $250 probation fee. That's the other condition. In return for the agreement to get the dismissal, you've given up your rights in paragraph 5 in the agreement. If there's a violation and the city proves by a preponderance that you violated the agreement, we'll have a hearing based on the police reports, and that will be the end of it. That'll result in almost certainly in a conviction. We don't want to go there. You have a chance to get this dismissed. Please do so. Sign off on the agreement. I want you to review a copy of it. You can get that at the window. And if you have any questions, give Mr. Haverko a call. You're also calendared for a consideration of a diversion agreement that was reached with regard to a DUI. And this goes back to 2017. Parties have an agreement regarding that, or?
I don't think the city is taking any action on that at this time.
Mr. Coleman, the city is not taking any action on that at this time. There are some requirements there. Alcohol Information School, Victim Impact Panel. Again, a conviction of DUI, that's mandatory jail time, that's license suspension, et cetera, et cetera. So you don't want to go there. Right. Bring yourself into compliance with the diversion. Signing the new agreement. Again, get a copy of it before you leave, review it carefully, and be in compliance. And if you have a problem making the fine payments, probation payments, let us know. That we can deal with. Good luck to you, Mr. Coleman. You take care. Have a good day.
Thank you.
Trouble closing. And that brings us back to, is it time to
I
go
don't know.
through
Is
the
it-
no-shows?
Is it time? Well, if we go to the 10 o'clock on the matter of Kevin Jones, I haven't talked to him, but based on that there was to be an arraignment on a new case, I had prepared a motion to continue on the pretrial matter if he were to appear, but I haven't, I don't know of his whereabouts.
We scheduled for the arraignment at this time as well, it looks like. Do Do we know anything about Kevin Jones? Was he the one that was referenced with Cody, what's his name, in that email about drug treatment? Moved it to today for the hearing. Let's see, you have a motion. Mr. Jones, Mr. Kevin Jones did not, ordered. That brings us to Ms. Sarah Shalhoub, who I understand, I'm given to understand that she is called and the car, once again, is not working right. There's something.
Okay.
That's, if I recall correctly, that's kind of a chronic situation with her, getting her to appear. They've released her from custody before on her promise to appear, and then she hasn't. So. Two matters are calendared. One, a compliance with a diversion, the other a pretrial hearing on a new crim tress. Warrant 1,000 each. Yeah, that's so ordered. Cash or bond. On the 11 o'clock, docket number 1, Axis Adamson obstructing.
I left a message with the phone number I'd been given, and I did not receive a return call.
So ordered. Danny Alford, that's another one of the drug.
Same on that. I've left a message to call back, no return call.
So ordered. You see, Mandy Downing has something in the.
Yeah,
in
yeah,
the,
I
Oak
spoke,
Court.
yeah. I had spoke with her at some point. That's why that was prepared. So but I wasn't given any information that she wouldn't be here today.
She has pretrial on DWS 3rd and theft 3rd on the following page. Total?
Yeah.
On Mr. Erickson, I believe I believe I'd spoken with him. It was another one of those reckless cases. And which I was hoping to resolve with.
And Mr. Erickson has a bond posted. That was city moved to forfeit. That's a forfeit reissue.
And when actually I would, on Mr. Erickson, I would just update this. I assumed I talked to him, but I made some notes and I have a phone number for him. I called the number. He hasn't called me back. But I haven't.
Warrant reissue 2,500, I think. Was what. 2,500. Forfeit. Tesla Kirsten Moore.
Yep.
Any contact with Ms. Moore?
No.
So ordered, 1,000 cash or bond. And that, I think, is that. Go ahead. I'm going to call the 1 o'clock arraignment calendar. I will eventually here call you up one at a time to answer the charge which brought you here today. Before I do that, I need to advise you that you have a right to have a lawyer represent you at all stages of any criminal proceeding. Mr. Haverco, our public defender, is here. He will enter a plea of not guilty on behalf of everyone here today and will represent you throughout the course of your matter if you're indigent and request his services. At this hearing, a plea of not guilty, as I indicated, is always entered. We set the matter for a pretrial, which gives you a chance to go over your case with your attorney and resolve the case by agreement if you can. If you can't reach a resolution by agreement, you have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. If you have any question regarding your rights or what you're charged with, go ahead and ask either myself or Mr. Haverco, who will be representing you. Is Diamond Basque Wessing in the courtroom? Sir, if you sit at the council table with Mr. Haverco, is your full name Diamond Kaoha Basque Wessing? I'm going to mispronounce it. If there's a way to mispronounce a name, I'm going to find it, and I apologize to each and every one whose name I mispronounced. How do you say your name, sir? Okay, thank you. The citation alleges in honor about October 1st, 2023, you committed the offense of driving while license suspended or revoked in the 3rd degree. Now, this is going to, resolution of this case is going to involve other people in the courtroom. So I'd ask you to pay attention to what I'm going to tell Mr. Basque Wessing.
Your Honor, city moves to amend this to a no law in the 2nd degree.
Hey, thanks. What happened here is just this. As you walked in here, you were cited with a criminal offense, driving a license suspended or revoked in the 3rd degree. Suspended but eligible for reinstatement is a simple misdemeanor. On conviction, you could be sentenced up to 90 days in jail and up to a $1,000 fine. The city has amended the charge to no valid operator's license on your person. That is a civil infraction. What that means is I can't impose any jail time. You're not entitled to a lawyer. If you admit the infraction, I'll assess a $150 fine. If you deny that you committed the infraction, you can set the case will be set for a contested hearing. Any questions about anything I just said? Do you admit or deny that when you're cited on October 1st, do you admit or deny that you, the allegation that you didn't have a valid license on your person? I'll assess a $150 fine. You can pay that at $25 a month. First payment due November 12th. Now I'm going to sign a order to that effect. I'm going to sign an order for everybody here. When you leave here, I want you to get a copy of your order by going to the window outside the courtroom and to your left. Review it carefully, and if you have any questions, either refer to us or Mr. Haverco, the public defender. I'm signing the order as we speak. Now, do you know what you need to do to reinstate your license? Now we live in a world where it's pretty hard to function at all unless you can drive. It's pretty easy to lose a license. It's a lot harder to get it back. What I would do is make it a project in life to get your license reinstated so you can drive without having to look in the rearview mirror to see if you're being followed at all. Mr. Vasquez, any questions at all? I'm going to wish you the best of luck. Good luck getting reinstated, and don't forget to get a copy of your order, okay? You take care of yourself. Would be James Bittner. James Bittner in the courtroom. Bittner, good afternoon. Is your full name James Anthony Bittner? Mr. Bittner, citation alleges in honor about October 1, 2023, you committed the same offense, driving a license suspended or revoked in the 3rd degree. Does the city have the same motion?
City does not.
I'll appoint Mr. Haverco to represent you in the matter. And again, this charge is a simple misdemeanor. The maximum penalty on conviction would be 90 days in incarceration and or a $1,000 fine.
Stipulate to probable cause, Your Honor, ask the clerk to enter a not guilty plea.
Mr. Bittner, we're setting the matter for a pretrial. Plea of not guilty has been entered on your behalf. Principal interest in this case is we'd like to see everybody get reinstated. We're going to set the everything is done on a computer screen, and that involves signatures of myself, Mr. Bittner, and Mr. Havercoat, and that sometimes takes time to process. That's what we're in the process of doing at this time. Is this matter already set for, the other matter already set for a
Did it
pretrial?
capture the signature?
Let's combine.
It didn't capture it. I don't know. Wait a second. Not yet. Try it again.
Mr. Bittner, your next hearing is set for October 26th at 10 o'clock. That's 2 weeks from today.
Yeah, it's in the phone number, so good. Okay. All right. Okay.
Go ahead and get a,
Okay, good.
concludes the hearing. Get a copy of the order at the window, please.
Your Honor, 26.
Dana Brown in the courtroom. Dana Brown. Good afternoon. Full name Dana D. Brown. Ms. Brown, the citation I have alleges that on or about October 7th, 2023, you committed the offenses of driving with license suspended third degree. As I indicated earlier, that's a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. You're also cited for operating a vehicle without ignition interlock. That's a gross misdemeanor. The maximum penalty on the conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Havercoat to enter a plea on your behalf, and he'll do so at this time.
Stipulate probable cause, Your Honor, ask, enter not guilty, please. Well, let's not talk about that.
Mr. Brown, any question about what Mr. Havercoat just said? He's entered a plea of not guilty on your behalf that preserves your rights pending a pretrial. Conditions of release are always law-abiding behavior. That would include having ignition interlock. That's required when you're driving. Any questions at all? Pretrial is November 9th at 11 o'clock. That'll be in the order, as well as contact information with Mr. Havercoat.
Well, we'll talk. Now's not the time.
Ms. Brown, thank you for appearing, and don't forget the copy of the order, and we'll see you in November. Thank you, ma'am. Is Michelle Sharon here? Charon. If I mispronounce your name, ma'am, I apologize. Ms. Sharon, you were cited on October 1st of this year with driving license suspended, revoked in the third degree, and failure to transfer title within 45 days. Each of those is a simple misdemeanor. The maximum penalty on conviction to be 90 days and or $1,000. City have the usual motion?
City to amend, he did the last third degree, but no on the second, and failure to transfer title within 45 days.
Yeah, it's civil infraction.
How do you pronounce your last name? Sharon? You now have two civil infractions. This, both charges have been amended. If you admit the infractions, I'll assess $150 fine each. If you deny them, you can set it for a contested hearing. That's your choice. Any question at all? What would you like to do? That is excellent, excellent. That was, there's a few sayings about that, but I'm glad to see you've gotten that taken care of. For some reason in this state, failure to transfer title within we're only one of 6 states where that's a criminal offense. Everywhere else in the nation, it's a civil infraction, so. But hey, that's it. I'll sign an order to that effect. Go ahead and take a copy of that now. Important thing is you make the payments on time. If you can't make the payments, let us know and we can certainly take care of that. But yeah, sooner you take care of it, better off it is. But ma'am, I thank you very much and I'm glad to hear that you're reinstated. Is it John Clark? John Clark in the courtroom? John Clark does not answer. At the end of the calendar, if there is probable cause for the issuance of the citation, I'll be issuing a warrant for the arrest of the people that did not show. So I want to thank you all for appearing today. How about Chloe Craig? Good afternoon, ma'am. How do you pronounce your last name? Is Chloe middle initial L Craig your full name? That's it. Citation alleges that on or about October 10th, 2023, you committed the offense of harassment, domestic violence. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate probable cause, Your Honor, ask the court to enter not guilty plea.
Ms. Craig, a plea of not guilty has been entered on your behalf. We're going to set the matter for a pretrial. Now, when I spoke to you in jail, I set conditions of release. One of them was no contact. And the other one was do not go back to the residence except one time with a Yelm police officer to get I understand there was a problem there. I think there's a little bit more to it than that. I want to remind you that is, if there's a violation of this order, I'm going to issue a warrant for your arrest and you'll be picked up and we'll revisit the issue of bail. But I want the peace to be kept. I want you to stay away from the residence. You've gone there, you've got what you need, and I want that to be the case. Do not go back there. Pre-trial's November 9th.
No. Oh, sorry. You won't see it. You won't see it. You don't see it. Yeah. Okay. And I need a phone number if you got one.
That concludes the hearing. I want you to get a copy of today's order at the window, and any conditions I said when I spoke to you when you're in custody, those remain in effect as well. That's we'll see you here in November. Take care. Justin Davis. I do not see Mr. Davis in the courtroom. We'll come back to that. How about Kimber Marie Faith? Kimber Faith does not answer as well. Joseph Forsythe. Good afternoon, sir. Is your full name Joseph middle initial L Forsythe?
Yes, sir.
Citation I have alleges in honor about September 26, 2023. You committed the offense of driving while license suspended or revoked, second degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Mr. Forsythe, the plea of not guilty has been entered on your behalf. Going to set the matter for a pretrial. It's going to take a minute. My screen seems to have been frozen.
You need to sign this.
Not yet. I have a frozen
Yeah,
screen. I've got the little thing spinning. Will not. Sorry for the delay. The cyber age isn't all that it's cracked up to be sometimes.
Oh, no.
Precise with this, I have now signed today's order. Get a copy of it at the window before you leave, and we'll see you back here in November. You take care of yourself.
Thank you.
Calvin Goodman in the courtroom. Does not answer. Daniel Hawkins. Does not answer as well. Amanda Huestis. I do not see Ms. Huestis. How about Jennifer Jenkins? Good afternoon, ma'am. True name, Jennifer, middle initial M, Jenkins. Ms. Jenkins, the citation I have alleges in honor about September 30th, 2023. You committed the offense of knowing possession of a controlled substance. That's a gross misdemeanor. The maximum penalty for that charge is 180 days in jail and or a $1,000 fine. I'll appoint Mr. Haverko to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Ms. Jenkins, a plea of not guilty is entered on your behalf. Set the matter for a pretrial on November 9th. Conditions of release, of course, are law-abiding behavior, and that would include no consumption of controlled substances. Any questions?
You don't need to. You'll pick up your paper before you go. I need a phone number before you go. Yeah.
Ms. Jenkins, thank you. Eric Koller, Koller. Good afternoon, sir. Full name Eric David Caller. The citation is for driving a license suspended or revoked in the third degree. City may have a motion in with regard to your case.
Yes, Your Honor, city moves to amend to,
The city has amended the charge from the criminal offense to the civil infraction. Do you admit? Well, first of all, do you have any question about what just happened?
No.
Do you admit or deny? I'll assess a $150 fine. Do you know what you need to do to get your license reinstated? I would check on that with the Department of Licensing. It would be my advice to get that straightened out as quickly as you can. I'll assess the $150 fine, $25 a month, starting November 12th. And again, I urge you to get your license reinstated. Any questions? I am now signing the order. Get a copy of that at the window. If there's any issue at all making the payments, let us know. We can easily deal with that, okay? Caller, thank you for your patience. You have a good day. Is Travis Lindsay in the courtroom? Full name Travis J. Lindsay. Citation is for the same thing, driving license suspended or revoked in the third degree on October 10th. Again, misdemeanor, maximum penalty, 90 days. The city is nodding in my direction. That is an amendment to the civil infraction of no valid operator's license. Any question about what just happened? Do you admit or deny the infraction? I'd ask you the same thing. Do you know what you need to do to get your license back, Mr. Lindsay?
no, I've never.
I hear that once in a while, they can't suspend my license. I never had one to begin with. It's actually what is suspended is your ability to get a license. Now that can be remedied, and sometimes it takes a lot of effort, time, and money to do that. I don't know what your situation is, but I'm gonna ask that you consider looking into that and getting validly licensed, okay? I'm signing the order. And I'll say the same thing to you. Get a copy of the order at the window outside the courtroom to your left. And if you have any issues making the payments at all, just let us know. We'll deal with it. Okay. So Lindsay, thank you. You take care. You have a good day. How about Courtney McKay? Good afternoon. Full name, Courtney Ray McKay. Ms. McKay, the citation alleges that on or about September 29th, 2023, committed the offense of driving a license suspended or revoked in the second degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Any question about the charge? I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Ms. McKay, a plea of not guilty has been entered on your behalf. We'll set the matter for a pretrial November 9th, 2023 at 11 o'clock in the morning. And conditions of release are always law-abiding behavior, and that would include, don't drive unless you're licensed and insured. Any question at all? Ms. McKay, I signed the order. Get a copy of it at the window, and we'll see you back here in November, okay? Thank you. How about Austin Miller? Good afternoon, sir. Is your full name Austin, middle initial T, Miller? Mr. Miller, the citation alleges that on or about September 29th, 2023, you committed the offenses of driving a license suspended or revoked third degree. Again, misdemeanor, the maximum on that would be 90 days in jail and or $1,000 fine. You were also cited for violating the ignition interlock requirement. That's a gross misdemeanor. The maximum penalty upon conviction for that would be 364 days in jail and or a $5,000 fine. What I'll do is appoint Mr. Haverco at this time to enter a plea on your behalf.
Stipulate to probable cause, Your Honor, and ask the court to enter not guilty, please.
Mr. Miller, a plea of not guilty has been entered. That preserves your rights pending a pretrial, which will be on November 9th at 10 o'clock in the morning. You don't need exchange contact information with Mr. Haverco. His information will be on today's order, so you'll be able to be in touch with him. Let him know how to get a hold of yourself.
And before you go, I need to. So before you go, let's see.
Miller, thank you. You take care of yourself. Thank you. You as well. Is Karen Elaine Moyna in the courtroom? If I mispronounce that, I certainly apologize. How do you pronounce your last name? Moyna. Citation I have alleges that on or about September 30th, 2023, you failed to stop and give information requested to a police officer. That's a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Would stipulate to probable cause, Your Honor, and ask the court to enter a not guilty plea.
There's been a plea of not guilty has been entered on your behalf. That preserves your rights until a pretrial, which we're going to set. And in the meantime, law-abiding behavior, okay? Stay out of trouble.
Didn't know I was doing anything.
Sign your name. No, I won't show.
Thank you, ma'am.
Where do you go? I need a phone.
360-458-1020.
Okay.
Thank you.
Thank you.
Thank you, ma'am. Cyrus Rosnick in the courtroom. Cyrus Rosnick. Does not answer. How about Bart Rowley? Brandon Tanderick. Robert Trevino. Mr. Trevino, good afternoon. Full name Robert Anthony Trevino. I know that, but I have to say that for the record. Citation alleges that on or about October 7th, 2023, you committed the offense of knowing possession of a controlled substance. Gross misdemeanor, the maximum penalty on conviction would be 180 days in jail and or a $1,000 fine. I'll appoint Mr. Haverco to represent you on this matter. Mr. Haverco.
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter a not guilty plea.
Mr. Trevino, a plea of not guilty has been entered on your behalf. Again, that preserves your rights pending the pretrial. Now, condition of release is law-abiding behavior, and that would include no consumption of controlled substances without a physician's prescription, okay?
You won't see it.
Trevino, thank you. You take care of yourself. We'll see you back here November, okay? Leodela Valencia Moran, and I'm probably mispronouncing that name, and for which I apologize for that. Okay, that's. Ma'am, you were cited for the offense you've heard a lot about earlier, driving a license suspended or revoked, 3rd degree. Does the city have a?
City does, city moves to amend the charge to no ball in the 2nd degree.
And by now, you probably know what that means. It's been changed from a criminal offense to a civil infraction, that you don't plead guilty or not guilty to a civil infraction. You admit it or deny it. If you admit it, you know what's going to happen. I'll assess a $150 fine. If you deny it, you're entitled to a contested hearing. Any questions about anything I just said? Do you admit or deny? Fine. 150 it is, 25 a month. Now, and I'll ask you the same thing. Do you know what you need to do to get your license reinstated? It's time and money, usually more money than time. But, and again, pretty easy to lose, a little harder to get it back. What I want you to do is get your license back and then make sure you keep it, okay? Any questions at all? I'm signing an order on today's hearing. What I want you to do is get a copy of it at the window outside the courtroom to your left. And I'll wish you the best of luck. You take care of yourself. Thank you for the patience you've shown, and I'm hoping you get your license back in short order. Good luck to you. Thank you, ma'am. And you as well. Cassandra Wadil Shoptaw. Good afternoon, ma'am. You are actually a recipient of the same citation, driving a license suspended or revoked in the 3rd degree. That's and by now, you probably know what's going to happen. The city's amending the charge from the criminal offense to the civil infraction. You came in a little late, and so you may not have heard that. The criminal offense, you were convicted of that, you could go to jail for up to 90 days. Civil infraction, all I can do is impose a fine, and that's it. So it's now no valid operator's license, 2nd degree. If you admit it, it's a $150 fine. If you deny it, you can set it for a contested hearing. Any question? Do you admit or deny? Deny? Okay, we'll set it for a contested hearing. Hearing will be on November 9th at 2:30 in the afternoon. At that hearing, the burden will be on the city to prove by a preponderance of the evidence that you admitted the infraction. We've signed the order. Setting the hearing, go ahead and get a copy of that at the window outside the courtroom and to your left. Any questions? Okay. Concludes the hearing. And for the record, Alicia Wade and Sean Wilson, neither of which appeared. Good afternoon, ma'am.
And Your Honor, before you is Mandy Downing. She was originally scheduled today on the 11 o'clock pretrial calendar, and she just arrived a little late. She's a caregiver and thought she wound up having an issue going on with work, so she's here now. We have an agreement. She signed a statement of defendant on plea of guilty. She's on for pretrial hearings on a theft charge, and then a suspended driving third charge. She intends on entering a straight plea to the theft charge. Upon the court's acceptance of the plea, the city will move to dismiss the other case with the suspended driving charge. The sentence recommendation is all suspended time for 12 months on the condition of no new criminal law violations and a $250 court fee.
Good afternoon, ma'am. Is your full name Mandy Renee Downey? Do you disagree at all with anything Mr. Haverko just said? I'm looking at on this computer screen, a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. The plea form tells me that you're 48 years of age. Any difficulties understanding, reading the plea form? Have you gone over the process with Mr. Haverko? And if you had any questions, were those questions answered?
Yeah.
I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 364 days and or a $5,000 fine. You realize that. That in mind is a 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on September 4th, 2023. How do you plead guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. I've heard the recommendation. Mr. Haverko, anything to add?
Nothing to add, Your Honor.
Mr. Ratcliffe, anything to add to the recommendation?
Nothing to add.
Ms. Downing, anything you wish to tell me? You don't have to say anything. You're shaking your head in the negative. I'm going to follow the recommendation. 364, all suspended on the condition. 1 condition, you have law-abiding behavior. 2nd condition, less important, pay a $250 probation fee. You can pay that at $25 a month. I'm going to wish you the best of luck. You take care of yourself. If you have trouble making the payments, let us know. We can deal with that. The most important thing here is law-abiding behavior. Stay out of trouble. I'm signing the paperwork as we speak. Sometimes I think this takes longer than the old way of doing it, handwritten form. Downing, it's been kind of a long day for you, but this concludes the hearing. Once again, I want you to get a copy of today's paperwork by going to the window, and that'll be given to you. Look it over carefully. If you have any questions at all, you know how to give Mr. Haverko a call, okay? Thank you, Ms. Downing. And with that, I think we can go off record. On record for the 1 o'clock no shows, first one I have is docket number 6, John Clark. Find probable cause for the issue and sue him of a DWS first charge, 2,500 cash or bond. Next one I have is Justin Davis, who usually does show up, but find probable cause for a crim trust 2 on him, 1,000 cash or bond. Faith Kimber, talked to her on October 2nd, gave her October 12th as a arraignment date, but she did just call. I think note the non-appearance and send her notice of a new court date. The next one I have after her is Calvin Goodman. I did find probable cause previously when he was in custody on docket number 13, criminal trespass 2nd degree, 1,000 cash or bond. And I think, given the diversions, 1,000 cash or bond on each docket 11 and 12. And that's primarily to preserve jurisdiction. Next one would be Daniel Hawkins. Page 13, number 14. DWS third amend to, no vol 2, and FTA. The next one is Amanda Huestas. I do find probable cause for her committing the act of theft upon leaving the courtroom after pleading to theft and from a co-defendant. 1,000 cash or bond. Next one I have would be Cyrus Rosnick. I do find probable cause for the issue and sue him of a theft third. He's already set for a pretrial next week, but hey, let's warrant 1,000 cash or bond. Next would be Mr. Rowley, docket number 23. Find probable cause for theft third on him, 1,000 cash or bond. Next one would be Bart Rowley, docket number 24. I did find probable cause when I released him from custody on October 6th with his promise to be here on October 12th. He has not appeared, 1,000 cash or bond. The last two would be page 15, both DWS third, amend each to no vol 2, FTA, and that takes care of the no. Oh, well. Back on record for the 2:30 contested hearing. I see somebody is appearing. Good afternoon.
Good afternoon, Your Honor. I am here for the attorney of record, Antonio Gargel, on the Ashley McLean matter.
Yes, ready to proceed on that. I've reviewed the case. I anticipate what your motions will be. Go ahead.
I'll start with, there was no speed measuring device listed in the officer's report that we received, and without that, I don't believe there can be a foundation established for that speed, and we can't access any type of speed measuring device without the unit being identified.
That was the first thing I noticed as well in the case. Your motion, please.
Would be to suppress the speed and then dismiss.
Motion granted. Move to dismiss.
Yes, Your Honor, thank you.
Citation will be dismissed.
All right, thank you so much, Your Honor.
I'm sorry for the delay. That was unanticipated. I want to thank you for your patience.
Oh, no, that's fine. I actually had just finished in another court and was running a little late, so
Okay. So
it actually worked out. All right.
likewise. Say you take care. Thank you for appearing, and I think I'll sign a order of dismissal and send it to you.
Okay, that would be great. Thank you so much.
Take care. You have a good day.
All right, you too, Your Honor. Bye.